Hello, NMAR members. I'm Ashley Strauss-Martin, General Counsel for the New Mexico Association of Realtors, and I'm here today to talk to you about the revised Residential Purchase Agreement, Form 2104, that will be released in the NMAR Forms Library in the next week to 10 days. The first change you'll notice is 4 pages in to the document. It's the first page of the purchase agreement after the first 3 cover pages, and it's an index. Now, we know that indexes typically come at the end of a document, but this one is at the beginning. And it alphabetizes all the various terms of the contract and then references both the page number and the paragraph number for each of those terms. Of course, the purpose of this is to easily be able to find any particular term in the contract, opposed to having to flip through the various pages. In paragraph 1 of the purchase agreement, you'll see a bit of different formatting for the buyer is going to buy and the seller is going to sell, and the date of the settlement agreement that has to be entered. But for the most part, it's the same language. But just below that section, you'll see a box that says sole and separate, and this is new. And the purpose of this box is if the buyer or seller is married, but the buyer or seller spouse is not appearing above under the buyer and seller name. And as a requirement by either the title company or the lender or both, one of the party who's married, whose spouse isn't appearing on this purchase agreement, must provide a sole and separate agreement to the title company or to the lender. And this paragraph requires not only identifying the fact that that's going to be required, but also creating an obligation for that buyer or seller, as applicable, to deliver or cause to be delivered a sole and separate agreement to the title company identified in paragraph 5 within so many days of date of acceptance. And this has become an issue because often the parties aren't aware that there's a spouse involved and that the property is either being sold as sole and separate property or purchased as sole and separate property until late into the game. And then when that sole and separate agreement cannot be obtained timely, then, for example, on the buyer side of the transaction, the buyer can't get the loan. And if they get a written rejection letter from the lender in time and provide it to the seller, the entirety of the earnest money is then returned to the buyer, and yet the seller wasn't aware that any of this was happening kind of to the 11th hour. And so we're trying to address this issue up front, identify in the event that the spouses aren't being identified here in this section 1, and require the party who needs the sole and separate agreement to provide that document in a timely manner so that everybody's not learning about the issue at the very last moment. Paragraph 3 is our off-market paragraph, and it simply says that the buyer is going to take the property off the market once the parties enter into this contract. However, we've clarified a couple of things, and then I want to add something to that. We have clarified the fact that the property will be off the market until one of 2 things should occur, and it's the sooner of these 2 things. It's either a termination of this purchase agreement or a default by the buyer that the seller doesn't waive or forgive. That's what's going to obviously stop the seller's obligation to keep the property off the market. I wanted to add that this paragraph doesn't speak to marketing, because I've gotten the question before as to whether or not this would prohibit a seller from continuing to actively market the property in some way so as to solicit backup offers. And this paragraph doesn't prohibit that. Matter of fact, it specifically defines or says what off-market means, and it means that the seller won't accept any other offers except backup offers. So it doesn't specifically speak to whether or not the seller can continue to market the property in some way, as long as obviously they're disclosing the fact that it's under contract, because otherwise that wouldn't be a very truthful representation to other buyers. And I will take this opportunity to make one comment about open houses, because that came up in this context as well. And I just wanted to say that, open houses are wonderful if you're trying to get a property sold, and it may be very beneficial even if it's under contract to solicit backup offers through an open house process. And I'm putting COVID aside for a moment. I'm not going to speak to that right now. But I did want to speak to the fact that there is some risk inherent in having open houses. There's actually a case going on up in Santa Fe right now where a visitor at an open house tripped and fell in a garage and actually injured themselves, was taken to the hospital directly from the open house, and they are now bringing suit against both the brokerage and the broker who was holding the open house. claiming that I think the garage wasn't well lit and that was the issue. But my point being is that if you're going to hold an open house once the property is already under contract or even before, you should be having these discussions with your seller about whether or not that's what they want. And it shouldn't be an open house strictly for the opportunity for the broker to solicit new buyers or to find new buyers out there on the market. It really needs to be for the benefit of the seller, and the seller has to not only make the decision that they want to have the open house, but they have to be well informed about just the nature of open houses, especially, again, not getting into the COVID issue, but we do have to be cognizant of those concerns as well right now, on top of just your general concerns about open houses. So I hope these conversations are being had on the listing side of the transaction so that the parties can, or the seller can, make the determination as to whether or not they want to have an open house in light of the circumstances. But again, this paragraph wouldn't prohibit that from happening in any way. In paragraph 62, our personal property paragraph, we made a few changes. You'll notice that we added unattached window coverings. We deal with attached window coverings in the fixtures section above. That's always been there. We broke down audio and video components into two separate sections. We broke down refrigerators into two sections: kitchen refrigerators and other refrigerators. So other refrigerators might be a refrigerator in our bar or a refrigerator out in the garage. We added garage door openers, and we put a number for the buyer to fill in, because that's who's completing this purchase offer initially. We note that if the number of garage door openers is left blank, then the seller's obligation shall be to provide no more than one working remote. But listing brokers, you want to be aware of that number when it's coming in, because if they put a number in there that is higher than the number that your seller has in remotes, then I'm afraid that's what your seller signed up for, and he may be asking you why you let that slip by. So be very cognizant of the number that's coming in there and making sure that your seller has that number of remotes available to provide. We also broke down fireplace gates and screens into two separate sections, and also we added pool and spa equipment, including any mechanical or other cleaning systems. Now you have to remember, again, this is personal property, this is not fixtures, and so you always need to come back to the definition of fixtures and the definition of personal property, which we have in our definition section of our purchase agreement. That's first and foremost controls. So everything in this section is assumed to be unattached to the property. It is not supposed to be attached, because if it is, it falls into the fixture section. Paragraph 7 of our purchase agreement is our cash loan or seller financing paragraph, and specifically the changes were made to 7A, which is the cash purchase section. And this was expanded upon to solicit some additional information from the buyer. If the buyer is buying with cash, we'd like to know where that cash is coming from. Is it readily available cash, so cash that's just sitting in a bank account just waiting for closing? Or is it contingent on the closing of a cash out refinance on another house? Or is there some other place that this is coming, a cash out on a 401k, for example, or some other place that this money is at the moment and not readily available? It also requires the buyer to produce proof or verification that money is in the buyer's possession and control and readily available within a certain period of time after the days of acceptance. In the event that the buyer doesn't provide that information timely, it also talks about whether or not the earnest money will be refunded to the buyer. This is a deadline default, and we're going to talk about our new treatment of deadline defaults in a few moments. We also made a small change to paragraph 7B5 of the purchase agreement, and that section is the section that addresses a situation where the buyer has a financing contingency, they're not able to get their loan, and therefore they're not in breach of contract because they do have this financing contingency. However, we have this strange little provision in 7B5 that says even though you're not in breach, you could lose your earnest money if you don't provide a written rejection letter to the seller within a certain number of days. The default is 3, but we have a blank there, so that number could be different than 3 if something is filled in the blank. And the purpose of this paragraph was we didn't want the seller to get the whole, U-Haul it all packed up and be driving out of the driveway when they find out that the buyer didn't qualify for the loan, and therefore that contingency wasn't satisfied and the buyer wasn't going to be closing. So that's the purpose of that paragraph. What we clarified is that if the buyer can't get financing, we're talking about the fact that the buyer can't get financing by the settlement signing date. So the way it was worded before, it almost made it sound like they had to be able to prove that they couldn't ever get financing. And what happens sometimes is that, sure, the lender may, say, hey, we're still in the process of trying to determine whether or not this buyer qualifies for this loan, and we can't say that they are rejected from the loan straight out because we don't know yet. We're in the process of still analyzing that. However, we know that they can't qualify by the settlement signing date. And the purpose of this paragraph is not to say that given an infinite amount of time, the buyer could never get financing. That's not the purpose. The purpose is to determine whether or not the buyer can get financing by the settlement signing date. And if they can't, that's the contingency. They're not in breach of the contract if they can't get their financing in place. Of course, that assumes that the buyer is doing everything that they can do to get that financing in place. They're participating in that process and cooperating with the lender and that kind of thing. So we've clarified here that in the event that the lender determines buyer will not qualify for the loan by the settlement signing date, that's a little bit different language than we had before. The other language that we added to this section says that this section will not afford the buyer an opportunity to cure. And I said in the last slide that we're going to be talking about that, and we will be talking about that. But the short of it is that in the event that the buyer misses this deadline, there's not going to be any notice requirement on the part of the seller. They will not have to tell the buyer they missed the deadline. The opportunity to cure will not be presented to the buyer. If they miss the deadline, they just miss the deadline, and then they run the risk, of course, of losing their earnest money as specified in this paragraph. I wanted to take a moment here to just show you that we have boxed off places where the buyers have to initial in the purchase agreement. I think there's one place where a seller has to initial as well. And I'm not talking about the initials at the bottom of each page in the right-hand corner. I'm talking about the initials that are kind of buried in the various paragraphs. I will say that we have not added any initials to any of those various paragraphs. So these initials that I'm talking about were already in the purchase agreement, but because they were kind of buried in these various paragraphs, they were getting lost. And so now we have pulled them out in this little box with the buyers. It either says buyers or it says sellers, depending on who has to do the initialing. And you'll see that in those same paragraphs that you saw the initial requirement before, only in this different format. Paragraph 13A is our title, liens, and deed paragraph, but we've now included assessments in that paragraph. So assessments used to be in a separate paragraph, and there used to be a separate period of time for objecting to assessments, but the assessments, more typically than not, will show up in the title work. So we felt like it made sense for that to all be in one paragraph, and for the objection period to any title issues to also be the objection period for any assessment issues. So that's where you'll find any kind of objections to assessments in this paragraph with title now. And it breaks it down. You'll see there's two sections now. There are objections to title exceptions. So buyer may choose to close subject to exceptions, remove the exceptions at buyer's expense, or terminate the agreement. If buyer timely terminates, it talks about earnest money. That was always there. That underneath there is an assessment objection period, and that's not different than what we had in the assessment paragraph. Again, it's just been moved into this section, and it says that the buyer may choose to close subject to assessments or to terminate the agreement. If the buyer chooses to close, the current installment of the assessment shall be prorated through the settlement signing date. And if they terminate it, the earnest money goes back to the buyer. So again, nothing changed with the way assessments were handled or being handled. We've just now combined it with the objections to any kind of title issues that were set forth in this paragraph on title, liens, and deed. Paragraph 13B is still our title paragraph, and it's a whole new concept that we're introducing. So whenever I talk about the contract, I know that we often want to blame third parties, third entities that we need to rely upon to get these deals done when things don't happen. So we want to blame the lender, we want to blame the appraiser, we want to blame the inspectors. But the reality of the situation is that there are only two parties to a contract, and more often than not, I mean, almost in every scenario, you can point to either the buyer side of the transaction or the seller side of the transaction when something doesn't happen. The buyer's responsible for getting the loan. If that doesn't happen timely, that's on the buyer side of the transaction. There may be a contingency provision. They may get their earnest money back if they provide a written rejection letter from the lender, but there's no doubt it was the buyer's responsibility. Same is true, of course, if for example, the seller is responsible for providing a survey and ordering that survey, then if that doesn't happen, that's the seller responsibility, and the seller, the seller failed to do what they were supposed to do, perhaps. But it falls on their side of the transaction, is my point. But the title commitment was a little bit different because everybody needed the title commitment. The seller has made certain promises to the buyer in the contract that they're providing, they'll provide a warranty deed, that they're going to, clear up all liens at closing. And we don't really know what those liens look like, or have that all the information to prove that the seller, can even issue a general warranty deed necessarily, until such time as we get the title information. On the buyer side of it, of course, they may want that information, but in the case of financing, they absolutely have to have that information. And so our title paragraph has always provided for a date by which the title commitment has to be ordered, but not a date by which it has to be provided, because we all recognize that we can't control when the title companies produce this. I know they work very diligently to try to get things done, in the time frame set forth in the contract for settlement signing, but that doesn't always work out. And particularly with the market the way it's been, it's not working out a lot. I think that the delays we're seeing in some of the bigger markets are maybe just a few days, but the delays we're seeing in some of the smaller markets, especially up north, are really large delays. I talked to a broker up there who I think told me that there was a 120-day delay on a title commitment from a title company up there. And what was happening in those scenarios, of course, you're coming up on the settlement signing date, you don't have the title commitment, and it begs the question, the way our contract currently reads, what are the parties' options at that point? Are they required to extend? Does one have a unilateral right to terminate the contract at that point? And if so, which one? Do they have does the contract automatically terminate? What happens in that scenario? And our contract didn't really answer that question. And that was creating a problem for buyers and sellers, because there were, financial hardships that they were facing as a result of these delays. A seller who may have had to get their property sold was, by the end of the year for tax purposes, was being hung up. A buyer who had a lock in on their rate was having to pay out of pocket for every extension, and that was getting quite costly. And yet it wasn't clear what their options were. So this is why we created this paragraph 13B. And this is what it says. It says that in the event that you're coming up on the settlement signing date and you don't have a commitment, then there is going to be an automatic extension. And when we talk about coming up on the settlement signing date, how close to that settlement signing date do we have to get in order to trigger that automatic extension? Well, the default is 5 days, but we have a space in that paragraph so that you can put something else. So if you want to say, if the parties want to agree to 2 days before settlement signing date, we don't have the title commitment, that's going to trigger the automatic extension. Or 1 day before the settlement signing date, that's going to trigger it. Or they want to say a week or 10 days, that's possible too. So we left it open for the parties to negotiate a number, but we also created a default, because if there's no number in there, then the question is, well, what kind of time frame are we talking about? So we've created a 5-day period. We figured 5 days before the settlement signing date is kind of the line in the sand, because the parties will need an opportunity to deal with anything that comes out of that title commitment, any issues. So whether they have to be resolved or whether or not there's objections to them, these kind of things. That 5-day period would give enough time for that to happen. But again, that's negotiable. So we come up on the settlement signing date and we still don't have the commitment within that time frame. There's going to be an automatic extension. And again, we have created a default, but we've also left the option open for the parties to negotiate something else. So the default is 14 days. There's going to be an automatic 14-day extension in the event that we don't have that title commitment within that time frame that we've set forth. If you're down here in Albuquerque, that might be way too long. You might need, a couple of days, but that's it. If you're up in northern New Mexico, that 14 sounds like that's not going to be sufficient, and you might want to put in 30 days or 60 days or whatever it is. You guys know what the market is. You know what's happening in your market. So you know what kind of delays these title companies are dealing with, and you're dealing with, and your buyers and sellers are dealing with as a result. So you guys get to kind of tailor that for the area that you're in and the delays that you're seeing. Then once you create this automatic extension, in the event that you're coming up on that automatic extension and you still don't have a title commitment, and again, we have a default of 5 days before the expiration of that automatic extension, but we leave it open for the parties to come up with another number, longer or shorter, as they see fit. Then at that point, then either party has the unilateral right to terminate the contract. So either party can terminate based on the fact that 5 days before the automatic extension expiration, we still don't have a title commitment, or 3 days if you filled in 3 days, or 2 days, or 1 day, or whatever period of time you filled in. Now, does this mean that the contract automatically terminates? No. It means that one party or the other has the right to terminate. So in the event that the parties say, hey, we're willing to continue to hang in there, you'll just do an extension, right? You'll just do another extension and another extension as long as the parties are willing to hang in there and it's working for them. But again, this creates clarity. So we're not automatically terminating the contract, and we're not requiring the parties to extend. We're giving them a right to terminate. And we create an option or clarity in what happens in these scenarios where these title commitments are not getting to the parties for long periods of time after the original settlement signing date. So I know it's a whole new concept, a new approach to this, but again, the way our contract currently reads, it doesn't provide enough clarity in that scenario. And again, people are being financially harmed as a result of it. So we needed to address it in some way, and this is what we came up with. Paragraph 15 is our cost to be paid grid, and we have 4 highlighted areas in this. 3 of them are new fees, and one of them is a fee that was already in our purchase agreement that's been moved into the cost to be paid grid, not a new fee, however. So first, let's talk about the title company closing cost. So there's 2 new fees in this section, and the reason for those fees is because there were some new regulations recently passed, title regulations, and out of that those title regulations came these 2 fees, and so we've had to address them in our purchase agreement. And those 2 fees are the prior title policy retrieval fee and the title policy cancellation fee. The prior title policy retrieval fee is a fee that would be charged by a former title company who had created a policy, who had issued a policy to a seller. And that seller, if they don't have a copy of that policy to provide to the current title company, then that current title company is going to have to reach out to that former title company and ask for a copy. And prior to the rule change, there was no obligation for that prior title company to provide a copy of that policy. But now there is, they have to provide it, but they can charge a fee for that, the prior title policy retrieval fee. So in the event that the seller has a copy of their policy, again, this is going to be a non-issue. They're going to provide a copy of that policy to the current title company, and this fee is not going to be charged to anybody. So it's only going to be charged in the event that the seller cannot produce a copy of that policy. And in that case, and 2 things, not only they can't produce a copy, but the company that issued that policy is not the current company, because obviously if it's the current company, they'll have access to that policy, even though it was issued before, sometime before now. But in the event that they weren't the policy issuer, they're going to have to go back to the original title company who issued the policy and ask for that policy, and there could be a fee associated with that. So that's what that prior title policy retrieval fee is. So if you're filling out this offer and you've already confirmed with the seller that they have a copy of that policy, then it wouldn't be required. But in the event that you don't know for a fact that the seller has a copy of that, then that needs to fall on the buyer or the seller to get that policy from the former company, or to pay the fee. The current company is going to request it, but the fee will be assessed. And then the second policy fee is a title policy cancellation fee. And in the regulations say if the transaction fails to close and no policy is issued, the title insurer or agency shall charge a cancellation fee. And this begs all sorts of questions, right? And creates all sorts of issues because, you would say, whoever is responsible, if somebody's responsible for it not closing, they should be the ones who are responsible for paying the title policy cancellation fee, right? So if it's the seller's fault that it didn't close, then it should be on the seller to pay that fee. And if it's on, the buyer created the created the situation where it didn't close, and it should be on the buyer side. However, you're not going to know that when you're filling out this purchase offer or accepting this purchase offer, because that's going to be way down the road, right? And yet we are trying to establish right now who's going to be responsible for that fee. And so this might have to be reworked at some point, but there's just so many questions surrounding this title policy cancellation fee at this point, that we're putting it here, and then we can change it if we need to change it. One of the things that I want to point out is that our default paragraph says that in the event that a party defaults under this contract, then the non-defaulting party is relieved from further performance. So in the event that there's a breach of the contract. So for example, the buyer breaches the contract, and the seller is obligated under this provision to pay for the cancellation fee, then certainly there's an argument that the seller doesn't have to pay for the cancellation fee, because when the buyer breached the contract, that relieved the seller from any further performance, which meant they were no longer obligated to pay this cancellation fee. So there's, and the same would be true in the event that the seller was the one who had breached the contract if the buyer had signed up to pay for this. So that is just part of the contract. That's the way our default paragraph is worded. And so certainly that would come into play here. The other thing that's going to come into play, of course, is how is this going to be implemented from a title company standpoint? Are they going to be looking at this contract and saying, well, whoever agreed to pay for it in here is going to be responsible for paying for it, and pursue that against that party, which would mean that that party, if they had to pay the title company, would then have to pursue it against the other party, right, who actually created the situation where it didn't close. They could still pursue that outside, but as far as the title company is concerned, are they going to just be looking at this? They don't usually like to get into assessing who created the situation where it didn't close. They just like to be able to look at the contract and say, this is who agreed to do this, and this is who we feel is responsible for doing it. The other question with a title company is, are they going to just expect whoever ordered the policy to be responsible for it? So again, are they going to look at the contract, or are they going to just say, the seller ordered this policy, and therefore when it doesn't close, we're going to assess that fee to the seller regardless of what the contract says? And then just from a practical standpoint, how are they going to get the fee? They're going to send something off to the buyer or seller when the transaction doesn't close and expect them to pay it? And if they're going to use them again, then maybe they wrap it into the next deal, or are they going to be pursuing these cancellation fees against buyers and sellers if they don't get their checks? I don't know. I don't think they even know how that's going to work out. I do know that a number of years ago, when there was a regulation change with the title rules, we added the paragraph under the policy premium section that says any fees charged by a title company to revise a title commitment shall be borne by the party who necessitated the revisions, because the rule said that there would be a charge for that. And yet in some of the bigger markets, they weren't charging for it. The smaller markets were. The bigger markets were just absorbing, the cost, and they weren't charging for it. So I don't know if that's the way the cancellation fees will work out. I read the language to you. It says shall. It doesn't seem to give them an option, but evidently, I think that the language dealing with the revisions also said shall, and some of them just choose not to charge it. So I'm not sure how this title policy cancellation fee is going to work out exactly. And maybe the title companies will have some paperwork, some documents that they have the parties sign up front that explains, who's going to be responsible for it or how they're going to collect it and these kind of things. But I think the regs are all too new for us to fully appreciate how those fees are going to be handled at this point. In the miscellaneous section, we have a new provision for elevation certificate, which is an additional cost. So in the event that the parties want, or the buyer wants, an elevation certificate, we have to figure out who's going to pay for that. And then the home warranty plan is in this section now. It used to be in the home warranty paragraph of the purchase agreement, which is still in the purchase agreement, but the cost of the home warranty plan is no longer in that paragraph. It's been moved to the cost to be paid grid, which makes sense because it's determining who's going to pay for it. So that's no longer in the home warranty plan paragraph. It's in the cost to be paid. Paragraph 21 is entitled Buyer's Investigation of Surrounding Area, and that's always been a standalone paragraph in our purchase agreement. And what it says is that the buyers are basically warranting that they have investigated the area, the surrounding areas, prior to entering into the contract. So they have looked at things like whether or not there are registered sex offenders that live in the area, or they have looked at, structures that may be either located or being built in the area that they like or they don't like, businesses that are operating, activities that are being conducted. All of this are things that they can look at before they enter into a contract and investigate beforehand. And the expectation by this paragraph was that they had done that, and that in the event that they decided after they got under contract they didn't like the fact that the property was located near an airport, or there was a sex offender that lived down the street, registered sex offender, that they wouldn't be able to use that as part of the inspection contingency and terminate the contract as a result. So this has always been in a separate paragraph, but during my legal update, I had told you that this was being moved into the inspection paragraph, and we were going to allow the buyers to do that kind of inspection during their inspection contingency phase. However, the committee reevaluated that and decided that that really wasn't reasonable. They felt like even in a market where the buyers are having to move quickly because they otherwise may lose out on the property, that they should have already investigated these things before they enter into a contract. So we moved it back out of the inspection paragraph, and now it stands on its own again. And it's important, I think, for buyers brokers, when they're going over the offer with the buyer, to point this out, that these are things that should have already been investigated, and that the buyer is basically warranting they have investigated prior to entering into the contract, and that it does not provide an out for the buyer if they should learn after getting under contract that there is a registered sex offender in the neighborhood, or there is an airport around the corner, or there is a waste transfer station down the street, or whatever the case may be. Paragraph 22H, the section dealing with objections and resolution, we've added some language to clarify an issue that evidently was not clear. We didn't have a provision that would allow a seller to do this, but we didn't specifically prohibit it. And so the question was, or did come up enough that we decided to add a sentence. So this is a scenario where the buyers made objections, and some sellers were under the impression that just because the buyer made objections, that gave the seller the right to terminate the contract. And so we've clarified in this section now that that's not the case. The seller may not terminate this agreement based on the fact that buyer made objections. The seller doesn't have any right to terminate. All they can say is no, right? No, I will not fix that. No, I will not reduce the price of the property. No, I will not give you a seller concession. No, 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 no. And if there's no resolution by the resolution deadline, then the contract will automatically terminate. The earnest money will go back to the buyer. But there's no provision for the seller to decide that they want to terminate in this process. And now we've made that very clear. Paragraph 32 is our definitions paragraph, and we've added a new definition or explanation of expiration date. And we explain that the expiration date is the date that the party is revoking his or her offer or counteroffer. We go on to talk about how an offer is no longer capable of acceptance after it expires, and consequently, if a party intends to accept the offer or counteroffer, it must be accepted before the expiration date. This next section is very important because I get questioned about this quite frequently. If a party intends to make a counteroffer, it does not need to be made by the expiration date, because a counteroffer serves as both a rejection of the original offer or counteroffer and as a new offer. So think about that for a moment, because again, this comes up quite frequently. If your seller or your buyer is going to counter, the expiration date is completely irrelevant because they are creating a brand new offer with that counteroffer. Okay? So the expiration date is very important in the event that somebody wants to, a party wants to accept an offer, because the expiration date serves as a revocation of that offer. It's as if that party on the other side picked up the phone or sent an email at that exact time and date, revoking, pulling that offer or counteroffer off the table, which means it's no longer capable of acceptance, right? So that's what that expiration date does. So if you want to accept an offer, it's very important to do so by the expiration date. And in the event that you want to counter, then the expiration date is of no relevance at all. You can counter at any point. Of course, if you wait too long, then I'm sure that buyer or seller is going to be gone. But you don't need to be worrying about that expiration date if you're going to counter. Sometimes a party will need more time to consider an offer. And so they, especially in a multiple offer situation with sellers, they may need some more time past the buyer's original expiration date. And if the buyer is so willing to extend that, they could send over an amendment addendum extending that expiration date. Because the idea being, and we explain this in our multiple offer form, that in the event that the seller wants to accept that offer, they're going to sign the offer, they're going to sign the amendment addendum extending the expiration date, and then you're going to have a contract, right? So you can always send over an amendment or addendum to extend that expiration date if the other party needs more time, and the party who made the offer or counteroffer is so willing to provide them with more time. The other point that I want to make about expiration dates is we have a provision in our contract that specifically says that you cannot create a contract by performance. And why is that relevant? If a party was to say that we don't have a signed contract exactly, but everybody's been acting like we have a contract, they've been performing like we have a contract, then there certainly is an argument to be made that there's a contract, right? So even though maybe we don't have a signed agreement that we're going to do this deal, we're all been acting like we're going to do this deal. And so we make it very clear that you need to have a fully executed contract in order for the parties to be obligated to perform. And just because they may have done some things that indicated that they were under contract doesn't necessarily create a contract. And this comes up in the context of expiration dates, because in the event that a buyer or a seller accepts an offer or counteroffer after an expiration date, and everybody starts walking down the path towards closing and acting like you have a contract, we can rely on the language in the contract that we have that says performance can't create contracts. But the truth be told, guys, it's actually difficult to make that argument the further down the path you get. Because the further down the path you get, the more it appears as though there is a contract. So, for example, if you accepted an offer after the expiration date, and then everybody started walking towards closing, doing inspections and appraisals and surveys and all of these things, and then right before closing, the seller claimed, hey, we don't have a contract because despite all of the performance that's been going on for the last 3 or 4 weeks, we accepted your offer after the expiration date, and therefore there wasn't a contract. Or the seller or the buyer made that same argument. It would be a hard argument to make despite the language in our contract that says that performance can't create contracts. So what I recommend in the event that you have a situation where a buyer or a seller wants to accept an offer or counteroffer after an expiration date has expired, instead of just relying on the performance of the parties moving towards closing, you can always do an amendment or an addendum that gets everybody on the same page, that recognizes the fact that the offer or counteroffer was accepted after the expiration date, but that the parties are ratifying the contract, they're agreeing that they have a contract, and that everybody is going to be obligated under the contract and intends to perform under the contract. So you can always just solidify that whole understanding of the parties by creating an amendment or addendum that says something along those lines. And I think it's important, again, even though it appears everybody's on the same page and we're all marching towards closing, because we have that specific provision in the contract that says that we can't create contracts by performance, only by a signed written agreement, and because the expiration date serves as a revocation of an offer or counteroffer, it's always a good idea to kind of get everybody on the same page and create an amendment or addendum that specifically recognizes, where the parties specifically recognize that they have a contract and are willing to be obligated by that contract and perform on that contract. So we've added an explanation of expiration date. I know that there are additional questions that may come up with that. Feel free to give me a call if that should occur. Paragraph 37 is our default paragraph, and we are introducing a new concept in this paragraph that is really a deviation from the way we've been doing business. So it's very important for everybody to understand how this works now. First of all, we've divided our defaults into deadline defaults and other defaults. Let me take a step back and just say that under our current purchase agreement, the default paragraph states that in the event that the there's a default in the performance of the parties, then the non-defaulting party, the party who didn't default, can cease performance. So what we've attempted to do there is we've attempted to define every default of our contract as a material default. And the reason that's relevant is because in contract law, the courts look at defaults as being material or non-material. Material defaults allow the non-defaulting party to cease performance, to stop performing on the contract, whereas a non-material default or a smaller default may not allow them to stop performance altogether. They may be entitled to damages, but they can't just stop performing altogether on the contract. So typically the fact finder, the judge or the jury, will make determinations as to whether or not something is a big default, a material default, or a small one. We try to take that subjectivity out of it and say that every default in our contract is a material default. I can't say definitively that a court would necessarily agree with that, but we do try to say that, and I hope that a court would follow what the parties had agreed to in the contract. However, in the event that we do provide a notice to cure, especially on some of these small things that may be perceived to be smaller defaults, for example, delivery of earnest money a day late, or delivery of a time fee a day late, or a pre-qual letter, these smaller defaults, in the event that a notice to cure those defaults is provided and then the defaulting party fails to cure the default within that period of time, there's even a stronger argument for the non-defaulting party that is a material breach, thereby relieving them from any further performance, right? That would strengthen their argument that was the case. And so we have now provided for a notice and an opportunity to cure. And so in the event that there is a deadline default, so there is a date by which something has to happen and a party fails to do it by that date, then the non-defaulting party will notify the defaulting party of the default, and it will provide that defaulting party with 2 days to cure the default. And if they don't cure the default within 2 days, then the non-defaulting party would be relieved from performance. So they would no longer have to do whatever the contract provided that they do, which essentially is, as a seller selling the house, as a buyer buying the house. So the reason we divide it into deadline defaults and other defaults is because there are lots of provisions of the contract that can't be cured, right? So for example, we have a provision that in the event the buyer wants to go onto the property, they have to have the seller's permission or the listing broker's permission to do so. In the event that the seller goes onto the property without that permission, there's no opportunity to cure. The horse is out of the barn, so to speak, and there's no way to kind of take that back. They've already defaulted. There's no way to cure that default. The inspection paragraph, the providing or the not providing, I should say, of the inspection report, that whole section that says that in the event that the buyer wishes to terminate, they will not send over a copy of the inspection report unless the seller asks for one in writing. If they're going to object, they're only going to send over the portion of the report that deals specifically with the objection that they have. So in the event that they do send that over, that's a default that can't be cured, right? And again, the horse is out at the barn. It's already been sent over to the other side. It can't be taken back. So we have a section B, 37B, that deals with those defaults. And we say those are material defaults. And since there's no opportunity to cure, that would automatically and immediately relieve the other party from further performance under the contract. However, there are deadline defaults in the contract that do allow for cure. So in the event that something has to happen, again, earnest money, tom fee, pre-qual letters, delivery of a document doesn't happen within a time frame, then those things can be cured. And those are deadline defaults where the notice would be sent out and the opportunity to cure would be provided to the non-defaulting party, to the defaulting party. So you're telling the defaulting party you have 2 days to cure the default. If they fail to do so, then the non-defaulting party, again, can choose to waive it. I mean, it's not as if they have to say, I'm done, I'm not going to perform anymore. They can choose to accept the default, to waive the default, but they also have the option of saying, I'm no longer performing under the contract. So this is a very new concept. I know that it's going to take a while to kind of get everybody up to speed on this. But we are going to attempt to do this now. And I'm going to talk to you now about this opportunity to cure notice that we've created that the non-defaulting party would send out if there was a deadline default of the contract. I also want to quickly note that when there's an objection deadline in the contract, so objection to surveys or objection to inspections or objection to documents or whatever the case may be, and the buyer doesn't make those objections in a timely manner, the buyer is not defaulted on the contract. And we actually have put some language in those sections to alert you to that fact and to alert the parties to that fact. Not objecting by an objection deadline serves as a waiver of their opportunity to object, whether it be to inspections or to surveys or to documents or whatever the case may be. You waive your right as a buyer to object to those things if you don't do so timely. So it doesn't serve as a default. It simply serves as a waiver of the opportunity to object. And again, we make note of that in the contract. Form 2112 is our new opportunity to cure form that I referenced a moment ago. And this is the form that the non-defaulting party will send out to the defaulting party. So it identifies the seller, the buyer of the property, the purchase agreement dated, and it asks for the date of full execution, so not the offer date. It says that the buyer or seller is hereby notified that they have defaulted on their obligations imposed by the purchase agreement in the following manner. And it has a place where the specific paragraph number of the purchase agreement can be referenced or the following addendum. And it allows for the details of the deadline to be entered, though that is completely optional. And then it also allows for the pages of the purchase agreement or the addendum referenced above to be attached. That's also completely optional. So the box would be checked in the event that those are attached, but in the event that they aren't, then that box would not be checked. The other important thing about this is the instruction to the defaulting party. It says that per the purchase agreement, the defaulting party has 2 days from delivery of this notice to cure the deadline default. If the defaulting party fails to cure the deadline default, then the non-defaulting party may elect to cease further performance under the purchase agreement. And in this event, the non-defaulting party may retain the earnest money and pursue any additional remedies allowable by law or equity. The other important part of that section is that we take the definitions of days from the definition section of the purchase agreement, because to this day, I still get questions about how do we calculate days in our contract. And we have that definition section specifically does address how days are calculated. And it says that days are determined on a calendar day basis, but if the final day for performance falls on a weekend or legal holiday, then it will roll over. The deadline for performance will roll over to the next business day. And it lists the specific dates or days that are considered legal holidays. So that is how days are calculated. So if a buyer or a seller is served with a notice to cure on a Friday, they would have 2 days to cure that. That would be Saturday and Sunday. You would count those because those are calendar days. But because Sunday is a weekend day, their opportunity to cure would roll over to Monday at 11:59 to cure that default. So you need to be aware of how to calculate days. It's going to be very important for purposes of calculating when the defaulting party has to cure that default in order to kind of save the contract, so to speak, or their position in the contract. And as I said at the beginning of this presentation, in the part of the contract that deals with the buyer providing a written rejection letter from the lender, that would specifically be excluded from the opportunity to cure. So in the event there is a deadline for that to be provided, however, in the event that the buyer doesn't provide it, that does not give the buyer, there's going to be no opportunity for the buyer to cure that. And again, we discussed that earlier in this presentation. So, the question will come up if they don't serve this, if the non-defaulting party doesn't serve this notification, then it's then what happens with the default? Well, it's kind of like one of those if a tree falls in the forest and no one's there to hear it, does it make a sound? If a defaulting party defaults and nobody's there to call them out and send them a notice to cure, is it really a default? So there's certainly, until such time as this notification of a default is served on a deadline default. And again, I talked about the difference between a deadline default and other defaults, but on a deadline default, in the event that this is not provided, then it doesn't trigger the default. It doesn't trigger the default until this is provided and the 2-day period has run. So again, be very much aware of how days are calculated. Be very much aware of the obligation of the non-defaulting party to serve the defaulting party with this notice prior to the non-defaulting party's rights to cease performance under the contract. Paragraph 47 is our force majeure paragraph. And, this pandemic has caused everybody, not just NMAR, to really revisit their force majeure paragraphs in their contracts because we realized that they were very much lacking. Courts will not imply or infer or consider force majeure events that are not specifically provided for in the contract for the most part. They really rely specifically on the language. And I think most contracts didn't really address pandemics until this whole thing happened. And then, of course, addenda has been created. We have a COVID addendum that addresses some of the issues that, COVID has brought up, whether it be government shutdowns or quarantines or these kind of things. But the force majeure paragraphs in most contracts have really been lacking to address this particular issue. So we revisited that and we kind of beefed this up, and we did define force majeure to include things like pandemics and government shutdowns and quarantines and unusual transportation delays and things that may come as a result of not just acts of God such as extreme weather and earthquakes and fire, but also pandemics, which I guess could be argued to be an act of God. But nonetheless, we've included that in the list, so there's no ambiguity as to whether or not that's included in as a force majeure event. We also then went on to say that in the event of a force majeure event, we are going to create an automatic extension in the performance deadlines in the contract. So, for example, if the bank shut down, then once they reopen, we're going to allow for an additional 10 days after that happens for people to perform on the contract. And in the event that the force majeure event lasts so long that you're going more 30 days or more past the settlement signing date, the original settlement signing date, then it will give the parties, either party, the unilateral opportunity to terminate the agreement. It won't create an automatic extension. So if the parties are so willing to hang in there and stay in the deal, they certainly can. But it does provide them with an opportunity to terminate if it goes 30 days past. When we were creating the COVID addendum, we were a little bit concerned about including vendors or inspectors or service providers in that list of kind of COVID related events if you couldn't get a hold of your inspector. Because what we were concerned about is that a party may just rely say I want to use this one inspector, this one repair person, and if that person was not available because of COVID, in the case of our COVID addendum, they had COVID, they were in quarantine or whatever the case may be, they couldn't get back from somewhere because of travel restrictions, then the buyer or the seller would use that as an excuse or to extend the contract and wouldn't be willing to look at other inspectors or vendors or what have you, so that the deadlines could be met. And so we worked, initially they were not in there, and then we ended up adding them into that COVID addendum. So they are included in here, in the sense that they could fall in some of these categories, again, because we do talk about quarantines and pandemics and government shutdowns and these kind of things and travel restrictions. But we did include a box, which again is very similar to what we have in the COVID addendum, that specifically explains that buyers are encouraged to determine the availability of home and other inspectors that the buyer intends to engage prior to entering into the agreement. Force majeure events may impact the availability of home and other inspectors, and vendors needed to conduct inspections and or repairs, and the parties are expected to deviate from their primary selection of inspectors and or vendors when necessary to meet the inspection and repair deadlines in the agreement. And the parties should be cognizant when setting these deadlines for inspections repair of the availability of inspectors. So, in other words, if you want to use somebody specifically and that they're not going to be available for 2 weeks, don't set a deadline for your objection deadline in the contract for 10 days, because that person is not going to be available, and you will be expected to find somebody else to do the inspection, because if there are other people available. Now, there may not be in some situations, but the idea being is that you can't rely on the force majeure language to say, I want to use this particular vendor or this particular inspector or what have you, and we'll just delay this whole process because that one person isn't available. Again, the parties are expected to look outside their primary selection if that's necessary to keep the contract on track and to meet the deadlines that are prescribed therein. If you have questions regarding the revisions to the purchase agreement, please contact me on the NMAR Legal Hotline. The phone is 505-821-1583 or email me at legalhotline@nmrealtor.com. Thank you very much and hope you all have a wonderful day.